So then I had a couple of miscellaneous questions about CYF and custody. So the custody question, I don't think the whole thing came up, but what can men do if mother violates the custody agreement? As part of the email list as an attorney for the court system, we get regular updates about court closings and things like that. And since I still do represent kids in juvenile delinquency court, that I am on the email list for family court. So I just did, this was in order that came out from the administrative or the administrative judge. So I just did a copy and paste. This is verbatim what she said about custody. If there is an emergency custody motion or emergency custody issue, then a motion must be drawn up, and then it's going to be addressed on a case-by-case basis. So, you know, it doesn't directly answer the question about what can men do if mother violates the custody agreement, because at the end of the day, it depends on what the violation was and whether that violation is considered an emergency. You know, with the consent of the parties, a matter can be addressed without a hearing, but I would assume, based on this question, that mom and dad would not agree to doing something without a hearing. So clearly an emergency is any violation that's going to put the health and safety of the child at risk. So if it's not something that's actually putting health, safety, and well-being of the child at risk, you know, risk of some sort of harm or death or injury, and it falls short of that, then how far short of that did the violation come? So the question as to what can men do, this is what they can do, but and the motion can always be filed, but they're only answering emergency custody motions right now because the courts are closed, with the exception of handling emergency custody motions. When it comes to juvenile delinquency, courts are closed with the exception of handling detention hearings, shelter hearings, things like that that are considered emergencies. And so if it's not an emergency and the motion gets filed, it's not going to be heard. So it really just depends on what the violation was. And is CYF or the court stopping visits with the child? I would suspect there's a little bit of both going on. There's been nothing issued from the court specifically stating that CYF needs to stop visiting the child, but I would suspect CYF has decided to stop the visitations due to social distancing requirements. Now, social distancing, technically, I think the requirement was no more than 10 people. So if you go into a home of 3 or 4, then you know you haven't violated it. But out of just public safety and health, it wouldn't surprise me if the administration has just decided to stop all the visits altogether, because you don't know what kind of home you're walking into, who might have the virus, who might not have the virus, and then that worker could take it home to their family. So nothing came out from the courts, but based on the fact that the courts are closed, because of all of this, CYF probably made that decision on their own to not do any visits right now. And if they're basing it on the fact that courts are closed, then this is going to go on for not having any visits, at least, is going to continue for I mean, it could be until further notice, which is the official language by the court on many hearings, until further notice. Again, unless there's an emergency. And this, the bottom part doesn't look like it doesn't look like it came up, but these PowerPoints were made available. So the bottom, the number at the very bottom, the 412 that got cut off, that'll still be made available. So I wanted to also talk about some additional considerations. I mentioned this beforehand, that this has been very big from the Department of Education, that education should be delivered distance learning, virtual classroom, or telephonically. Teachers are encouraged to be creative and collaborative with parents. And then compensatory education, which I mentioned beforehand and touched on briefly, but there has been the language from the Department of Education telling school districts that they may have to, just acknowledge and consider and expect to pay out compensatory education if they're unable to deliver goals or deliver education in a manner that effectuates the goals of the IEP. So it's not, it's not an ideal situation having to do compensatory education because you're having to make up for lost time and lost education, but it is something that it's a reality that we're going to have to deal with right now. So it really just depends on what are the goals, and what are we trying to measure, and if someone's behind, how far behind are they, and then what's being done currently to address those issues. And all of that depends on the school district. Some school districts are better than others. I've had clients who have said, yes, the teacher is great and is almost at my child's beck and call. Every time I call or have a question, she's immediately there. And I have other clients that are like, I haven't heard from anyone. And I've emailed numerous times and I don't even get a response back from the teacher. So, in those situations, I reach out to the lawyer to find out what's going on and to interject before it gets worse. But those are situations where, if you've been emailing the teacher since March the 20th, we'll just say, and we're now April 7th, and you still haven't heard back from the teacher, received any information, well, all those days are days lost. And so that could certainly qualify for compensatory education, even if they respond today or tomorrow and get you everything that you need. If the child is still behind by the end of the year because of the time lost, then you can still get that back in compensatory education. So what we don't know, and I wanted to throw this in, is whether the states will be allowed to seek a waiver on meeting their obligations under the IDEA. And I wanted to mention this because that's an issue that's come up. And I wasn't sure how many people were aware of it, but the states are getting together to request the Secretary DeVos to waive their obligations under the IDEA. Basically saying that it's just too much, they're overwhelmed, they can't handle it, they can't deal with it, and they don't want to be obligated to deliver, deliver the goals on the IEP. And so that's a question that's up in the air, and that's a question currently being considered by the Department of Education, whether the states will be allowed to seek a waiver. Now, even if they're allowed to seek a waiver, it doesn't, of course, necessarily mean Pennsylvania will seek a waiver, but I have no reason to think Pennsylvania wouldn't seek a waiver either. Philadelphia wasn't educating any kids because of claims that they couldn't educate children with IEPs. So it wouldn't surprise me if Pennsylvania did seek a waiver, but I just wanted to put that out there to let you know that that is an issue that's come up, that's currently coming up. And so what does that mean? If the states were able to waive their obligations, then all of this would be, they wouldn't be in violation of anything. So if they didn't have compensatory, where they ordinarily would have compensatory education, and they would have to provide, set up an education fund or tutoring or ESY or whatever the case may be, or not ESY, but just some sort of extra schooling in order to compensate, they would not be required to do that because of, if the claim is due to COVID-19, they would not have to do that. So, not to end on a negative note, but it's pretty significant information that I didn't want to just not share while I have everyone here, especially with you guys. I don't know if I would necessarily scare the parents, but since you guys are service providers, I at least want to make you aware of that issue if you weren't already aware of the issue. So that's the end of my presentation. I will open it up to questions.
Okay, Jennifer, this is Misty. Thank you so much. That was a lot of information.